I've been on the bench for 27 years. I've watched murderers confess, families break apart, officers falter, and victims finally breathe. But until that Tuesday morning, I had never seen a sheriff stand up, interrupt my ruling, and watch the whole courtroom slowly turn against him. It was 9:03 a.m., generic mid-sized U.S. city, Department 3, case number 24-417, CR flashes on the monitor, State of Northwood vs. Daniel Ortiz. A simple suppression hearing on paper, nothing about it looked historic. On the left, at counsel table, the defendant, Daniel, 29, EMT, navy polo with his ambulance company logo still stitched on the chest, shoulders tight, fingers locked together. His public defender, Ms. Holloway, sat beside him, gray blazer, legal pad already filled with dense notes. On the right, the prosecutor, Assistant District Attorney Lewis, tie a shade too bright for the gray walls, files stacked in precise color-coded piles. And in the second row, leaned casually against the wooden pew, arms folded over a dark green uniform, Sheriff Wade Hollister himself, elected 3 terms, starched sleeves, polished badge, catching the fluorescent lights. Even in this dramatized story, let me be clear, sheriffs don't usually sit in my gallery unless something about the case touches them. And when a sheriff shows up that early in full dress uniform, it's almost never good news. And that's when everything changed. Not for the defendant yet, but for the balance of power in that room. I called the case. State of Northwood versus Ortiz, 24-417 CR. Counsel, announce your appearances. Good morning, Your Honor. AD Michael Lewis for the state. Public Defender Karen Holloway for Mr. Ortiz, who is present and seated to my left, Your Honor. I glanced at the clock. 9:05 a.m. Gavel lightly in my hand, I summarize the issue for the record. This is defendant's motion to suppress statements and physical evidence obtained during a traffic stop on June 14th at approximately 22:43 hours. Allegations include unlawful detention, excessive force, and coercive interrogation. We're here to determine admissibility. Those are clinical words, but underneath them lives a story. According to the report, Daniel was driving home after a double shift, still in his EMT gear, when a sheriff's deputy claimed he swerved, nearly hit the median. The stop escalated. By the time it was over, Daniel had a separated shoulder, a cracked phone, and a charge sheet that read like a shopping list: resisting, obstruction, disorderly, DUI. He insisted he hadn't been drinking. He insisted he'd begged them to check his body for bruises. He insisted he'd asked for a supervisor. The supervisor that night was Sheriff Wade Hollister. And guess who signed off on the incident report? I started the hearing with the deputy. Deputy Cole Renner, mid-30s, buzz cut, uniform neat but not as crisp as the sheriff's. He walked to the stand with that mix of confidence and tension I've seen in 100 law enforcement witnesses, back straight, but eyes flickering just a little too often toward the gallery. Deputy Renner, raise your right hand. Oath administered. He sat. Deputy, I began, walk us through the stop. He told a familiar story, late night, a white sedan drifting between lanes. He activated his lights at 22:41, approached cautiously, smelled what he believed to be an alcoholic beverage. What happened next? Ada Lewis asked. Driver seemed agitated, Your Honor, fidgety, hands moving too fast. He refused to step out of the vehicle. At counsel table, Daniel looked down, jaw tight. Ms. Holloway lightly tapped her pen on the pad. 1, 2, 3, a tiny drumbeat of skepticism. Did you fear for your safety?
Yes, sir. I believed he might be reaching for a weapon. And that's why you removed him from the vehicle? Yes. The official report lined up neatly with his words, almost too neatly, but the next detail stopped the room cold. Deputy, Ms. Holloway began her cross, voice even, what was my client wearing when you removed him? Ma'am? His clothing. What was he wearing? Dark shirt, maybe a t-shirt, jeans. She took 3 slow steps, heels clicking on the tile, and held up a photo. Exhibit D, Your Honor, taken on scene by a bystander from roughly 6 feet away, according to metadata. In the image blown up on the screen, Daniel was pinned against his own car, arms twisted behind him. The emblem on his shirt was unmistakable, Northwood County EMS. He wasn't in a t-shirt, he was in his EMT uniform. I watched the jury box, empty for this hearing, and then the rows of pews. A murmur rippled quickly, then died as I lifted my hand.
In the second row, Sheriff Hollister's jaw flexed. He shifted, big ring tapping lightly on the wooden rail. Deputy, Holloway continued, is this the man you stopped that night? Yes, ma'am. Is that your hand on his shoulder? Yes, ma'am. And you see the emblem on his chest? He squinted. Looks like EMT logo, yes. So when you wrote in your report that the defendant was wearing a dark T-shirt suggestive of gang affiliation, that was false? Lewis shifted in his seat. Hollister's arms tightened. Objection, Lewis jumped in. Argumentative. Mischaracterizes the report. Overruled, I said quietly. He can answer. Deputy Renner swallowed hard. I must have misremembered when I wrote it up, Your Honor. A misremembered shirt, Holloway said, and a misremembered profession? No note that he worked in emergency medicine? Silence. What happened next made the whole courtroom go silent. Holloway took a breath. Your Honor, at this time, I'd like to introduce Defense Exhibit E, a short video clip taken from across the street. It shows the stop beginning 30 seconds before Deputy Renner approached the vehicle. Lewis frowned. We haven't seen this, Your Honor. It was provided to the state last week, and I have the email receipt, Holloway replied, holding up her phone. I checked the clock. 9:21 a.m. We were less than 20 minutes into what was supposed to be a routine suppression hearing. I nodded to the clerk. Lights dimmed slightly as the screen came alive. In grainy cell phone footage, the white sedan rolled to a smooth stop. No swerving, no jerking. You could hear the faint echo of radio chatter, the buzz of a distant street lamp, then the heavy footsteps of the deputy. He approached, hand already on his holster. No slurred speech, no obvious aggression, just a tired EMT explaining he'd just finished a double shift. At 0:47 on the video timestamp, Renner yanked open the door without any visible lunge from the driver, and within seconds, Daniel was shoved into the frame, then into the car. I've watched enough raw footage to know when a narrative is cracking. Sheriff Hollister shifted again, now leaning forward, eyes locked on the screen. He whispered something to the sergeant beside him. When the lights came back up, the air in the room felt heavier. Deputy, I asked, why didn't you mention that the defendant identified himself as an EMT? He stared at the microphone. Didn't seem relevant at the time, Your Honor. Leaning back, I made a note on my yellow pad. At the top of the page, I wrote one word, credibility. And that's when everything changed. As if on cue, there was a discreet knock at the side door near the bench. My bailiff, Carter, slipped through, a folded note in hand. We never interrupt testimony lightly. Carter didn't look rattled, but he didn't look casual either. I took the note, eyes scanning the neat block letters. Special Agent R. Keller, FBI Civil Rights Division, present in gallery. Request brief sidebar at first appropriate break. I glanced up. Third row back, center aisle. A man in a dark suit met my eye, then looked back down at the file in his lap. No badge flashed, no theatrics, just quiet, patient attention. This is a dramatized composite story, but I can tell you this much from real life. When federal civil rights shows up unannounced at your suppression hearing, something bigger is running beneath the surface. For the moment, I tucked the note under my pad. We weren't at a break yet. Counsel, I said, we'll continue. Ms. Holloway, anything further for this witness? She smiled without warmth. Just one thing, Your Honor. She played the clip again, stopping at the exact moment where Daniel, hands still on the steering wheel, said clearly, Officer, please, my shoulder's injured. I'm an EMT. I just got off shift. No sudden moves, no threats. Deputy, she said softly, when he said that, you had two choices. Treat him like a drunk problem or like a human being telling you he was hurt. Which one did you choose? Lewis objected again, but the answer was already hanging in the air. I sustained the objection this time, but the damage was done. The jury box may have been empty, but the courtroom audience was very much listening. If you want more real courtroom stories, dramatized but drawn from what really walks into these halls, make sure you're subscribed. It helps these lessons reach more people who think justice is just a word on the wall. Now, back to that sheriff. Holloway finished with the deputy. Lewis tried to rehabilitate him on redirect, but each answer felt thinner than the last. By 9:38 a.m., the deputy was excused. He stepped down, studiously avoiding the defense table. I turned to the state. Mr. Lewis, any additional witnesses? He hesitated, glanced at Hollister. The sheriff gave a subtle nod, as if giving permission instead of requesting it. That told me more than any testimony could. The state called Sheriff Wade Hollister. There it was. Hollister stood, smoothed his uniform, and walked to the stand with the swagger of a man who'd won 3 elections and probably broken up bar fights before most of the jurors had finished high school. He took the oath without flinching. On direct, he painted a picture of a department under siege. Too few resources, too many calls, constant danger. He described arriving on scene just after the takedown, hearing raised voices, smelling alcohol, though the video hadn't picked that up. "Did you instruct your deputy to use force?" Lewis asked. "I instructed him to maintain control of an agitated suspect, yes." "Did you see anything that concerned you about his actions that night?" "No, sir. Everything looked by the book." Everything looked by the book. Problem was, the book I follow is called The Constitution, and the pages of his didn't quite match. During cross-examination, Holloway pulled out another exhibit, a letter on official sheriff's department letterhead, signed by Hollister, submitted to my court 2 months earlier. In it, he described Daniel as a combative, likely intoxicated suspect who posed an imminent threat to officer safety and assured the court that no video exists that contradicts the incident report. "Sheriff," she said, holding up the letter, "when you wrote this, 'no video exists,' had you made any effort to check with your deputies, dispatch, or the public for recordings?" He shifted. "My understanding was there was no video from our systems." "That's not what you wrote." A small beat. "It's what I meant, but the next detail stopped the room cold. Because, Sheriff," she continued, sliding another paper across, "your office received an email from a citizen 3 days after this stop with the subject line, 'Video of Ortiz traffic stop.' It's time-stamped, and it includes a link to the exact clip we just watched." She projected the email on the screen. My clerk zoomed in on the received field, the recipient, HollisterNorthwoodSheriff.gov, his official address. The date, June 17th, 8:12 a.m. 3 days after the stop, 5 days before he wrote to my court saying, "No video exists." I heard someone in the back whisper, "Whoa!" Carter's hand hovered near his holster, not because of a threat, but because tension has a sound, and it had just gotten loud. Hollister's face flushed, color climbing from the collar up. "Sheriff," I asked, breaking my usual distance, "did you receive this email?" He stared at it. "Your Honor, I receive a lot of emails." "That's not an answer." He exhaled sharply through his nose. "It may have come to my inbox, yes." "Did you open it?" "I don't specifically recall." What happened next made the whole courtroom go silent. I turned to Holloway. "Counsel, anything further?" "Just one more question, Your Honor." She stepped closer. "Sheriff, when you tell a judge no video exists, and a video like this has been sitting in your inbox for days, is that an honest mistake, or are you trying to protect your deputy at the expense of the truth?" "Objection," Lewis shouted. "Argumentative, Your Honor." I raised a hand. "Sustained. Jury will disregard the last question." Even in a hearing without a jury, old habits die hard, but before Holloway could rephrase, Hollister snapped. He tore his gaze from the screen and looked straight at me. "Your Honor, this has gone far enough," he said, cutting across both lawyers. The words hit the room like a dropped glass. "Sheriff," I said slowly, "you will not interrupt counsel or the court. You are a witness right now, not an officer in command." He pushed himself up higher in the chair. "With all due respect, sir, I've kept this county safe for 15 years. I'm not going to sit here and let some edited phone clip and a defense lawyer who hates cops tell you how my department works." "Sheriff, no," he said, voice rising. "This is my courtroom too. My men risk their lives out there, and you sit up there second-guessing every decision we make." My bailiff stepped forward, boots echoing on the tile. The gallery froze. No shuffling, no coughs, just a hard, suspended silence. The sheriff had just interrupted a sitting judge on the record in open court and effectively claimed the courtroom as his. Power works in quiet ways, so does its reversal. "Sheriff Hollister," I said, my voice low but very clear, "sit down now." For a heartbeat, he didn't move. Then he obeyed. "If you think moments like this, when the mask finally slips and the truth surfaces, matter, hit the like button and tell me in the comments what you would have done in my place. It helps more people see how thin the line is between authority and abuse of it." I leaned slightly toward the mic. "Let the record reflect," I said. "The witness has interrupted the court, raised his voice, and challenged the court's authority. Sheriff, you will remember where you are." In the third row, the man in the suit, Special Agent Keller, wasn't writing anymore. He was just watching. We took a brief recess. In chambers, I finally met with Agent Keller. He confirmed what I already suspected. Daniel's case wasn't isolated. There were at least 3 similar stops under review, all involving night shift EMTs or nurses leaving the hospital, all written up by the same small cluster of deputies. The email with the video, it had been one of several tips to both the sheriff's office and federal authorities. Back on the bench at 10:12 a.m., the air felt different. More eyes, more phones tucked into purses, more reporters at the back, pens hovering. News moves faster than my docket ever will. I addressed the courtroom. We will resume the hearing. Sheriff Hollister, you remain under oath. He looked tired now. Some of the starch had left his uniform. Sheriff, I said, I'm going to ask you a simple question, and I expect a direct answer. When you wrote to this court stating that no video exists contradicting the incident report, was that true at the time you wrote it? His attorney, hastily summoned during recess, sat in the front row, hands clenched. But the sheriff had insisted on staying on the stand. Pride has a way of pulling you toward the edge, even as the ground erodes. I believed it was true, Your Honor, he said. Belief and truth are not the same thing. Did you know at the time that there might be a video? He hesitated. I had heard rumors of a recording, yes. Did you instruct anyone in your office to look for it? No. Did you instruct anyone to ignore it? His jaw worked. I told my staff not to chase down every random clip that shows up in the inbox, yes. And there it was. The quiet part spoken aloud. Enough. Here's what we're going to do, I said. First, I'm granting the defense motion to suppress. The stop, as I've seen it, lacks reasonable suspicion for the level of force used and for the subsequent search. Every charge that flows from that stop is now unsupported by admissible evidence. I turned to the prosecutor. Mr. Lewis, I suggest you speak with your office about whether continuing to pursue this case is a good use of taxpayer resources. He nodded, looking pale. Second, I continued, eyes back on the sheriff, I am making a record, on the record, that the sheriff's department failed to follow up on a citizen-provided video that directly contradicted an incident report, and that the elected sheriff submitted a letter to this court that was, at best, reckless with the truth. You could feel the weight of each word land. Third, I said, as of this moment, I am ordering that the email and the citizen's video be forwarded to the State Attorney General's office and to the U.S. Attorney's Office, Civil Rights Division, for independent review. Hollister's eyes flashed. Your Honor, with all due respect, we're not done, I said. Finally, Sheriff, you will show cause as to why you should not be held in contempt for your conduct in this courtroom this morning, interrupting counsel, interrupting the court, and attempting to leverage your badge to influence these proceedings. You will return this afternoon at 2 p.m. with counsel for a contempt hearing, case 24417 CRC. I had written that new case number myself a few seconds earlier, a beat of silence. Then, for the first time that day, Sheriff Wade Hollister looked like a man who understood he was no longer the largest presence in the room. We reconvened that afternoon. The camera for the record showed a different posture. No casual lean, no folded arms. The sheriff's tie was slightly crooked. His attorney spoke first, arguing that his outburst had been a lapse in decorum born of stress, not malice. That his misstatement about the existence of video had been negligence, not perjury. He apologized. To me, to the court, to any citizens who feel their trust was shaken. I listened. I weighed. That's what we do on the bench. We weigh the weight of a moment against the totality of a life. In the end, I found him in contempt of court, not for being a flawed human being, but for crossing a line that cannot be crossed by anyone, especially not someone entrusted with a badge. He was fined, ordered to attend remedial training in courtroom procedure, and referred in writing to the state's Law Enforcement Standards Board. I did not remand him into custody that day. The handcuffs stayed on his belt. But make no mistake, the balance had shifted. Within 6 months, as Agent Keller would later quietly confirm, an independent investigation led to reforms in the sheriff's office. Deputies were retrained. Some left. Policies were rewritten under the unforgiving light of outside review. And in the next election, Sheriff Hollister lost by a margin that reflected more than just politics. It reflected trust, once cracked and never fully restored. As for Daniel, the charges were dropped. He went back to his ambulance, back to patching up the same community that had nearly branded him a criminal for driving home tired. One afternoon, a year later, I saw him in the hallway, in uniform, escorting a patient from the elevator. Our eyes met for half a second. He didn't smile, didn't wave, he just nodded, a small, almost imperceptible nod. the kind you give when you've seen both sides of power and survived. Here's what I want you to take from this dramatized story drawn from far too many real afternoons on the bench. Courtrooms are not owned by sheriffs or prosecutors or defense lawyers. They're not even owned by judges. They belong to the truth. Badges matter. Robes matter. Titles matter. But they matter only as long as they're tethered to accountability. The moment someone with a badge believes the rules are an inconvenience to be managed instead of a covenant to be honored, the whole system tilts. I've seen officers stand up and admit mistakes with humility. I've seen them protect the vulnerable at great personal cost. Those are the stories that never make the evening news, but they're real. Grace exists in these halls, but grace without truth is just good manners. So when that sheriff interrupted me, when he tried to make my courtroom his, the most important thing I could do wasn't to raise my voice. It was to plant my feet and remind everyone, including myself, that this room has only one true authority, the law, applied with courage. If you remember anything, remember this. Power looks like a badge or a bench, but real authority is the willingness to be accountable to something higher than yourself. If this story held you to the end, there's another one you need to hear. The day a courtroom sketch artist captured a tiny detail in her drawing that changed an entire jury's mind. It's about how one overlooked hand gesture in a child custody trial turned the case upside down. Watch that next. And keep your eyes open. In my courtroom, it's always the small things that explode the truth.